certainly didn't do that, and then otherwise make proper efforts to prevent the commission of the offense. And what, if you were the prosecutor, what would be the one thing you would say, other than the fact that he didn't do either of these, to say he certainly didn't do any effort, much less a proper one, to prevent the commission of the offense, Mr. Johnson?
Did you share the answers with me?
He kept participating in at least the fruits of the poisonous tree, right? So he didn't do any of these things. Okay, as you might imagine, the law is very, very strict on this issue of withdrawal. In Kentucky, okay, under KRS 502.040, it requires the same complete and voluntary renunciation of the role of an accomplice that we talked about when it came to attempt. Remember, we talked about attempt, that if you wanted to abandon an attempt, you had to completely and voluntarily renounce it. And that meant that you couldn't be motivated, even in part, by a fear of being caught. Right? So a 502.040 says, for withdrawal, there must be complete and voluntary renunciation. And then it sets the same standard for what constitutes withdrawal as we see in Formella. The accomplice must, pursuant to KRS 502.0402A, deprive his prior effort of its effectiveness, right? Deprive its prior effort of its effectiveness in helping accomplish the crime. And under 502.0402B, either give timely warning to law enforcement officials or make proper effort to prevent commission of the crime. Okay? It does not require that you actually prevent the crime. But if you do, make sure that whatever you did to help it is nullified, no longer is effective, and you tell police or law enforcement officials, here's what's going on, so you've done everything you can do, but the crime still happens. What you can say is it didn't happen even in small part because of your participation. So if you meet the requirements 502.0402A and 2B, you have a withdrawal defense, but that is really, really hard.
Could we say under the KRS that because he only intended to leave to go to the first floor and did not intend to actually leave the building completely, that him changing floors was only fear of being caught, and then he was ordered out of the building by the janitors, so that he did not really.
I think that would be a fact question. That'd be a fact question, because he would still be able to argue, at least as to his renunciation, that going to the first floor was intending to, and it was, because he had a change of heart. He realized this was wrong. Not he feared he was getting caught, but he feared it was wrong. So on at least the issue of voluntary renunciation, I think you'd have a fact question. Now, that still wouldn't have wholly deprived him of his aiding of effectiveness, so he wouldn't meet that prong at all. But he might meet the voluntary renunciation part. At least, if I were his lawyer, I'd say, I at least can argue that to the jury and want to get an instruction on it. Okay? Yeah.
So how would an undercover police officer get out of being charged as an accomplice if he goes all the way through the completion of the crime?
Well, first of all, one would hope that a prosecutor is not going to be charging undercover police.
Right.
But under the letter of the law, if for some reason, let's say the prosecutor became suspicious of the undercover officer's motives or involvement or things that he or she did, what would you say is the reason why the actions of an undercover officer, participating in meetings, etc., would not fit within aiding and abetting? And
the mens rea, maybe you wouldn't have a mens rea?
you'd have a mens rea issue. Good. What else? That's good. Capital for that. What else?
If he did his job, then he eventually turned over all the information to law enforcement. That made his.
What is built in? I'm using this as a baton. What is built in to this test? is the assumption built into at least one prong of this test?
That whatever he did wholly deprives its effectiveness of the crime.
Reverse that, because the assumption is we're going to deprive it of its effectiveness. That's what withdrawal is. So what's the assumption before we ask the question about depriving effectiveness?
That he did an act that promoted the effectiveness of the crime?
That the aiding and abetting added to, helped promote the crime, and we want to nullify that. An undercover officer would argue, look, my actions didn't add to the effectiveness and accomplishment of the crime, they were undermining it. My very presence there gave evidence to how he could prosecute them. My very presence there meant that everyone wasn't completely loyal, etc. So I didn't have to take any action to withdraw to deprive my actions of effectiveness in the, I love this. My actions were themselves harmful to the commission of the offense. So there was no need to do anything beyond being an undercover officer to deprive my prior actions of their effectiveness in helping the crime. They didn't help the crime. Now, presumably the prosecutor would say, well, wait a minute. Yes, that might be the ultimate goal, but unfortunately the actions of undercover officers sometimes, in order to set the trap or the sting for the ultimate defendants, they have to actually, help them do things, because you have to gain the confidence of the people you're working with. You have to infiltrate, and infiltrating can help. You're another body to help do things. So the argument could go both ways, but that's how I would argue it, is that the very fact that you're there as an undercover officer doesn't even give any effectiveness, so you don't have to deprive it through withdrawal.
What if someone's intention is to aid and abet, but their actions actually end up hindering the crime?
I think that would make this easier to prove, because you have less to deprive. You don't have to deprive much effectiveness. Maybe you don't have to deprive any effectiveness at all. So technically I think that might work. Good luck with that. Because any prosecutor worth his or her dime is going to be able to show that anyone who gives any aid, any assistance, gave some benefit to the accomplishment of the crime. Now, a clever law professor might come up with a bizarre fact pattern that would contradict that, but that would be unusual, to say the least. Okay? Let's talk about the mental element of complicity. And the question we're going to ask here about mental element or mens rea is whether the accomplice has to share the mens rea of the principal, or does the person have to have the distinct mens rea to aid and abet? Right? If you think about that, if somebody wants to kill, if somebody wants to kill Kanye West, right? Taylor Swift. If somebody wants to kill Kanye West, then that person their mens rea must be shown to be intent to kill Kanye. If I am aiding that person, do I have to have the same mens rea, i.e. share the mens rea to kill Kanye, or do I have to have the specific mens rea to aid and abet? Is that its own distinct mens rea? And that's what we'll talk about. The differences are mostly insignificant when the defendant purposely helps a principal bring about an illegal result, but they become significant when the purposes of perpetrator and helper diverge, right? And the perpetrator causes harm perhaps carelessly rather than purposefully. Let's talk about Beeman, okay? And in Beeman, we're going to ask the question, is knowledge of the person's criminal intent enough to satisfy the mens rea of complicity? Yes, ma'am.
I was gonna.
Go ahead. That's what I mean.
Tim Beeman was convicted for aiding and abetting James Gray and Michael Byrne for robbery, burglary, false imprisonment, destruction of telephone equipment, and assault with intent to commit felony.
They sound like charming dinner companions.
Yeah.
These two. And whom did they commit all these acts against?
His sister-in-law.
that is the defendant's sister-in-law,
Defendant's sister.
Marjorie Beeman, right?
Yes.
And how did they accomplish these crimes? How did they go about accomplishing these crimes?
So before all of, well, I guess okay. So James Gray and Michael Burke, drove to Reading to rob the appellant's sister.
And they had first called her to see if she was home, right?
They first called her to see if she was home. Then they went to her home. Burke knocked on the door. She answered. He pretended to be a poll taker.
Now, she's no dummy. Did she just let him in when he says, I'm a poll taker?
No, she asked for his identification.
And good for Marjorie Beeman for that. And how did Burke respond?
He forced her into the hallway, so I guess he was pushed in, and Gray entered with the ski mask on.
Ski mask, you say?
I know.
Miss Harper, because everyone needs to be in disguise today,
Oh, that's a good one.
okay?
She
I
got,
think my disguise is much better than Gray's, but reasonable minds could vary.
says ski mask.
Ski mask is the phrase of today. Very good. So he follows her in, and they secured her in the bathroom, ransacked the house, took a bunch of jewelry, set of silverware, some rings. All told, $100,000. More than $100,000. So she apparently had some valuable stuff that they were able to steal. Okay. So how did Beeman get involved in all of this?
So, he was arrested, and they found possession of the less valuable stolen rings on him.
And
And
he's caught first.
he's caught first, yeah.
Burke and Gray are still at large. How did they get caught?
Well, he tells the police about them, and then Gray eventually gives some of the stolen, or most of them, stolen items.
And it's based on Gray's cooperation.
Right.
So Burke and Gray plead guilty to
Robbery.
good.
And then the appellant has a separate trial, and Burke and Gray testify that he was extensively involved, and that he supplied information of the layout of the house, discussed the method that they used to rob her, told them what to wear, and agreed to sell the loot for 20% of the proceeds.
And that kind of, we got Beeman dead to rights, don't we? Beeman's got nothing to stand on.
Yeah.
Beeman may as well start counting the years on his prison sentence. Or does Beeman have a little sliver of hope?
Well, in Gray's testimony, he said shortly before the robbery, Beeman said that he didn't want any part of it, and he was angry afterwards, but they did find the stolen items on him, so.
And he, of course, that's their testimony, right? They sort of testified he'd been involved in the planning, he gave them valuable information, but Gray then also says he did say he wanted no part of it, was angry that it had been committed. Beeman, for his part, denies everything. Denies the whole thing, contradicts their testimony as to almost every material element of his own involvement, which of course is a problem since he had some of the stolen items. But that's his story, and he's sticking to it. So what aspect of the jury instructions does Beeman challenge?
So they, so first he asks, if the jury can be instructed that aiding and abetting liability requires proof of intent to aid.
He does, he asks for that instruction, the trial court says, forget about it, no, refuses the instruction. And how do we know that this was, or how do we have at least strong suspicion that this was important?
Because it was part of the common law.
I mean, in this particular trial, how do we know that that this was important to potentially, at least, the outcome of this case?
Because he wasn't part of the actual defendant.
Not what I'm getting at, Lineweaver?
The jury had,
The jury, what did the jury keep doing?
they kept asking for more clarification
On?
they wanted to hear if, how one is formed to be an accessory, by what actions can he absolve himself, and then does inaction mean the party is guilty?
So there's clearly the jury was focused on this, at least aspects of this issue. And so we can't say, certainly couldn't say with any confidence, that if this was a mistake, if the jury should have been instructed about this in the way that Beeman wanted, that it affected the jury's deliberations. So we can't say it was harmless error by any stretch of the imagination, right? All right, so what do the California model jury instructions say, and whom do they support?
So they say those who, with knowledge of the unlawful purpose of the one who directly and actively commit or attempt to commit the crime, aid and abet in its commission, or who, whether present or not at the commission or attempted commission of the crime, advise and encourage the commission.
So what mens rea do the model jury instructions? The model jury instructions are put out there as guidance to these trial judges. What mens rea do they suggest Beeman had to have?
Knowledge.
Knowledge. Knowledge that they were going to commit this crime, right? Now, the thing you need to know about model instructions is they can be wrong. They're put out there, presumably if an issue has been decided by the state's Supreme Court, then the model jury instructions will reflect that decision. But if it's an issue that hasn't yet been decided, like here, all the drafters of those model instructions can do is make their best guess as to what the state Supreme Court will ultimately think about that issue. And so this is not somehow controlling law, because if it were, you'd have to say, this is puzzling, because the California Supreme Court says, ultimately, this is not enough. But the answer to the puzzle is to remember that if the California Supreme Court, in this case, or whatever state you're talking about, if the state Supreme Court decides, no, this is wrong, those model jury instructions have to be tossed and revised. Okay? So that's a reason why if you're the prosecutor, you're going to say, judge, to the trial judge. You're going to say, judge, the model instructions tell you all you need to know. And they say all he had to have was knowledge. Tell the jury that all he needed was knowledge. He didn't have to share their intent. He didn't have to intend to aid and abet. If he acted, if he did something with knowledge that actually aided and abetted, that's enough. So says the model instruction, so says the prosecutor, so says the trial judge. Is that right, Ms. Nair? No, that's not right. He says, that is Beeman, that it permitted the jury, this instruction, permitted the jury to convict him, this is on 804, without finding that he harbored either the same intent as Burke and Gray, or the specific intent to assist them. Okay? And so why does the California Supreme Court say, yeah, Beeman, you are correct?
Because the mental, or they say the facts from which the mental state may be inferred must not be confused with the mental state that the prosecution is required to prove.
And what is the value of knowledge? What is the importance to the ultimate verdict of the fact that an accomplice knows of the criminal purpose that he or she is aiding and abetting?
Because they can, if, like the last case, like even if they withdrew or whatever, they have the ability to prevent or try to stop that.
Let me ask it another way. If you're the prosecutors, and this case goes back on remand, we know the California Supreme Court has said intent on Beeman's part to aid and abet is required. Okay? That's what's required. The jury's going to be told, you must find, ladies and gentlemen of the jury, that the defendant intended to aid those who burglarized and imprisoned, etc., Ms. Beeman. As the prosecutor, does this then become irrelevant?
No,
What are you going to argue is its relevance?
because they had knowledge and they didn't do anything to, or I guess because they had knowledge and they didn't do anything to stop the furtherance of the commission.
And what is the significance? What are you going to argue the judge should tell the jury, and what are you going to argue to the jury is the significance of knowledge?
That knowledge is indicated of intent,
And what should the jury do?
infer.
The jury may and should draw an inference as to intent. What may it not do?
Presume.
I'm sorry?
Presume.
No presumption. Remember, we've seen this before. The one doesn't substitute for the other, and the prosecutor is not entitled to a presumption, so knowledge does not give rise to a presumption. And if you're the defense, that's what you're going to stress. You're going to stress, ladies and gentlemen of the jury, the prosecution wants you to rely on the mere fact that it argues that my client knew what Burke and Gray were going to do. But you cannot presume that from his knowledge. You must independently find intent. The prosecution is going to emphasize the inference. Yes, we don't presume one from the other, but we can infer one from the other. Yes, ladies and gentlemen of the jury, we must prove to you that Mr. Beeman intended. But you may infer that he intended from the fact that he did, from two related facts. He gave aid, and he gave aid knowing what they were all about, knowing what they intended to accomplish. And if you put those together in an equation, the one plus the other equals intent. You can infer, and we will have proved to you beyond a reasonable doubt that he intended to do that which he, with knowledge, aided in the doing of. So that's the balance the court draws. This is the legal requirement. This can support an inference that it is met, that legal requirement is met, but it is not a legal presumption. Okay, and that's how the jury should be instructed, that it's not a legal presumption. Okay, so as the court puts it on 805, the aider and abettor must share the specific intent of the perpetrator. Right? He must act with the intent or purpose of facilitating the perpetrator's commission of the crime. Okay? If you do not have intent, if you only have knowledge, that does not mean that the Beemans of the world get off the hook. Okay? If you have knowledge, you have the crime of facilitation. If you look at KRS 506.080, the crime of facilitation, that occurs when a defendant acts, quote, with knowledge that a person is committing or intends to commit a crime, and with that knowledge, the defendant engages in conduct which knowingly, boy, knowledge is in there twice, with knowledge and knowingly, provide person with the means or opportunity for the commission of the crime, and which in fact aids such person to commit the crime. Okay? That's facilitation. The difference between facilitation and complicity is the difference between knowledge and intent as the mens rea. So facilitation, 506.080. Complicity is in 502.020. If you look at 502.020, you will see complicity, that's the complicity section, it requires the defendant to act not with knowledge, but with the intention of promoting or facilitating the commission of the offense. Okay? We got that? We're all the way back to mens rea, right? The semester comes almost full circle.
So the takeaway, which book did we take in this case with regards to mens rea is that knowledge isn't enough to prove intent, however, the jury can infer intent from knowledge.
Now, plus the act of giving the aid.
Okay.
Right? If you just have knowledge and you don't do anything, then you don't even get the next step into. So it's not, it can't be complicity because you haven't aided. But you can, the combination of the two, you can draw that inference. The jury don't have to, but it can. But that's the conclusion that has to reach, intent. Right? So we reinforce some old mens rea concepts.
So you can't have an intent to aid and abet because you haven't actually aided?
Who said that?
I don't
Did
know.
I say that?
KRS requires intent,
I
right?
didn't say that. No, you can have attempts to aid and abet, but you, again, it's distinguished from facilitation because you intended. Maybe you just failed miserably. You're a really bad accomplice. And either the crime itself didn't occur, and under some circumstances, I'm not going to get into the details of that, but under some circumstances that can render it only an attempt, or you didn't actually render any aid. Maybe the crime still occurred, but you were a complete flop. Maybe you were supposed to be the getaway driver, right? And you didn't show up because your car broke down. So they got another getaway driver. You had every intention to aid their robbery of that bank, right? Or the thievery of those exams. But you didn't actually aid and abet. Under those circumstances, now it would be a really hard case for the prosecution to prove, but you might get turned in, right? They may decide to turn on you. So you could be charged there with attempted aiding and abetting. But again, with that, you definitely, as we all know, I hope, recall, attempt is always a crime of intent. So if it was attempted aiding and abetting, attempted complicity, then you've got the fact that complicity itself is a crime of intent, and so is attempt. So it's double.
Would Tally have been guilty of attempted murder if the answer to that first question is yes, if the other two no?
No. If, then he might be guilty of, would you say he was guilty of?
Would he be guilty, like he couldn't be guilty of murder without those, but could he have been guilty of attempted murder if he did something with the intent to help them murder Ross, but his efforts, let's say like his telegram never got there?
I think it would depend on why the answer to those questions was no. If it was that his efforts were meaningless, I think you probably have to settle for attempted facilitation, not attempted complicity, because he would not, because remember, since complicity is not itself a crime, you'd be charging him with murder, but he wouldn't have actually aided and abetted murder, and it wouldn't be attempted murder because Ross will actually die. So you can't aid and abet something and charge them with a crime that didn't occur. Right? So I think that would be the barrier. The facilitation, I think you could get. Attempted facilitation. All right, let's start at least Wilson. This is one of those bizarre cases.
Well, I just had a question.
Sure.
The procedural one. So since we're like saying that the model jury instructions were like in error and they basically throw those instructions out, what happens to like people who previously been convicted from those jury instructions?
In many situations, those people's convictions would stand because they would have already had their, presumably, they would have taken their appeals would have been exhausted, and it might not be applied retroactively. In this situation, because the court held it was a due process violation, that to convict without a finding of intent wasn't just contrary to the law, like the statute, and that's why the model jury instruction was wrong. But in violated due process, if I'm representing one of those people, I'm going to bring a petition for a writ of habeas corpus and say that it is unlawful to continue to hold my client in violation of his or her constitutional rights. And so you could proceed that way, assuming that claim has not already been raised and rejected. Because I don't want to get deep into the weeds of habeas. I mean, how many of you want to go deep into the weeds of habeas today? I didn't think so. But the basic premise is you can't raise repetitive claims. So if that claim has already been made and rejected, let's say, for example, the California court had changed its mind. that had already rejected this claim in the past. And the Beeman lawyers were just so good, they convinced the court to rethink it. If you've already litigated the claim, exhausted it through a habeas petition, you can't bring subsequent habeas petitions. Again, there are some exceptions to that, but that would be much more difficult. But since it's a due process case, and since, let's assume, those prior defendants who are sitting in jail had not raised that before, habeas would be their route to try to get those convictions overturned. Okay? All right. Wilson. What is Wilson charged with? Mr. Razor.
He's charged and convicted under 2 counts of having unlawfully and felony aided and abetted and assisted one in the commission of burglary.
Aided and abetted whom?
Dwight Pierce.
Mr. Pierce, in the commission of burglary and larceny. And what's Wilson's defense to this?
That he lacked the intent to commit the crimes in question.
And why is that?
Because he acted as a decoy to detect the commission of the crime.
And to report it to the proper officers so that Pierce might be apprehended. He is a hero, in other words, or so Wilson says. He's sort of an undercover cop without the cop part, in a way, okay? So how did all this arise?
So Wilson was at a cafe when Pierce enters. He had been drinking a place where he could purchase more liquor. So Wilson tries to help him with that, and so they leave to the commercial hotel where Pierce works. Pierce borrows some money. He says Wilson goes and tries to get whiskey, but he can't find any, so he gets gin instead. They get a bottle of gin, and they go back to the cafe where they originally met, and they drink some liquor. During this time...
This does not go well, right?
Never.
Why not?
During this time, Wilson sees that his watch is missing. He accuses Pierce of stealing it.
Now, what do you assume must be true, although it's not quite said, once you get to this point in the story? That he suddenly discovers his watch is missing and he accuses Pierce of stealing it.
Wilson's been drinking as well.
Wilson's been drinking, right? Because this whole thing suggests, A, he's not very aware of his surroundings, and he's got a quick trigger, a temper, and so alcohol is definitely affecting everything that happens from here on out. Very good, excellent. So he says, Pierce, you took it. They argue so loudly that they're asked to leave the cafe. And they went to another cafe, they kept arguing, and they thought they would be thrown out of that place too. So now what happens?
They go back to the commercial hotel where they get onto the topic of Pierce's past crimes, and he mentions that he burglarized Wheat Growers Cafe the previous week. So then they get on the topic of the list of tools that would be needed for a burglary, and then one of them mentions robbing the Heckler Brothers drugstore.
Because that's where all the money is, a drugstore.
Yes.
But yes,
And
they need these tools, and Wilson says, well, I can get you these tools, right?
Yes. And then they proceed to the drugstore where they find that it's blocked and there's no way in. So Wilson agrees to lift Pierce up to a glass transom.
And what does that constitute?
Leading a
Wilson
standing-
lifts Pierce.
It sounds like.
In your, you are listing the elements of the crime and then the facts you could use as the prosecutor to prove that crime. What does the fact of Wilson boosts Pierce into the drugstore? What is that as your fact, and how does that support or help you prove what element?
In the jury instruction, it says that they must stop short of lending assistance, and so that would point to assistance.
That would point to,
Assisting or aiding and abetting.
that is the act. Very good, excellent. right? That's your act of aiding and abetting. You need that. You can't have complicity without an act which aids and abets. You can have all the thought you want. Well, I really want to help Pierce because I want Pierce to get caught. Let's say that's Wilson's real motive, right? I want to help Pierce. But if you don't do anything, then it's just a random thought, and we don't punish thoughts. So we need the act, and we've got the act, right? That is as clear an act rendering assistance. If somebody wants to steal from a drugstore, and you help them get into the drugstore, you have aided the accomplishment of the crime. Everyone see why actus reus here is not the issue. Actus reus is definitely not the issue because Wilson is caught dead to rights taking an act that aids and abets the accomplishment or the commission of the crime. Okay? We got that. We'll stop there. I can stop itching. Good. Lots of comments. Very good. Good job. Pick up.